Hello and welcome back to the 2021 First Amendment Congress. Again, my name is Andy Moore. If you're just joining us, welcome. I'm the Executive Director of FOI Oklahoma. And for our next panel, we've got three excellent panelists to be sharing information. This one's called From What You Wear to What You Share, The Limits of Free Speech on and Off Campus. Now, if you joined us for our 9 o'clock discussion from Joey Sinnott, you heard some of that information and some really great tangible illustrations of where our intersection of our rights and the education system meet. And we're going to kind of further or continue that conversation during this session. So joining me today for this is Joey Sinnott. We'll add him back to the screen. Hi, Joey. Also joining us is David Hudson from the Free Speech Center. Hi, David.
Hey.
And then Tony Childers from the Oklahoma State School Board Association. Hi, Tony.
Hi.
I intentionally did super brief introductions with just your name and title because I would like to hear a little bit from each of you about where. I mean, we'll answer this question. I'll call on you, and you can say, what do you feel is the most important nugget? Well, right off the bat, what's the most important thing that students should know about the limits of free speech on and off campus? Does that make sense? The most important thing students should know about the limits of free speech on and off campus, and then we'll get into the discussion. So, Joey, since you've already been in this brain space for an hour, I'm going to start with you.
Oh, I was trying to get out of the way of Tony and David. So, I think the point I left students with a minute ago was, you have to know what your rights are. And by the way, it's not always clear cut. Otherwise, we wouldn't need attorneys to decide this. But know what your rights are. And if you think they're being violated, then stay calm so that your actions in response to that censorship don't become the issue. But, you have to know what your rights are. Otherwise, it's just too easy for people to take them away from you when you don't have a clue that you had them in the first place.
Yeah, that's exactly right. Thanks, Joey. David, I'll go to you next.
I agree with Joey. I also, on the other end of that, I would say that students really do need to appreciate that, particularly online communication, that you can't just do whatever you want. While the U.S. Supreme Court has, I thought, issued by and large a darn good opinion in the Madnoy case back in this summer, social media is not a legal free zone, and you can defame people, you can invade their privacy, you can engage in cyberbullying. And so I think a good lesson for all of us sometimes, particularly in politically polarizing times, is to think before we post sometimes.
That's sage advice. I don't care how old you are. That's very important. Thanks, David. Tony, how about you?
Yeah, so I may take a little bit of I come from a different side of things since I work with schools for the most part in my career. And what I would say is very similar to what the other two panelists said, is you have to be careful what you post online, but remember that schools are limited in how they approach student speech. And as you probably heard earlier in the prior presentation, students, you don't shed your rights at the schoolhouse gates. And now with this newest case, Mahanoy, we know that there's a limit in terms of how far a school can go outside of those gates. So one thing I always try to tell my schools as well is when it comes to student speech, it's really not about the content of the speech. It's always about how is that affecting the school's ability to carry out its mission, which is to educate students. So it's not really about the content of the speech. In most cases, there are exceptions to that. It's more about how is this affecting the school day and affecting the school's ability to educate students.
Tony, can I follow up on that and ask you, do you see, and this, I won't hold you to the answer here, but do you see that uncertainty or confusion about where that line is more on school's end or on students' end, or is it really a combination of both?
since I primarily deal with schools, I could only talk from the school side of things, but there is a lot of uncertainty, and that leads to lots of questions from schools, or maybe even a misunderstanding of thinking a student did this particular or said something particular, we're going to suspend them, and hopefully they give a call to their retained attorney or to our office and ask a question, and we help guide them through the analysis of, well, just because you disagree with what they said doesn't mean that you can automatically react to it. So there is definitely, I don't want to say confusion, but uncertainty when it comes to the line of when something is happening at home, whether it be a comment on Facebook that's perceived as bullying or threatening, or simply just a statement made by a student on their own time, where is the school's limit in how they can act?
Yeah. Well, and I think Joey shared an example in his earlier presentation of the student who had the condoms taped to their shirt. And the school board member said that they found it personally offensive. And that was like a clear misunderstanding of what the law allows and who's the one there. David, I want to ask you a question more about students then. We host an annual First Amendment essay contest in conjunction with this First Amendment Congress, and we hope to be announcing the winner later this morning. One of the things I took away from reading dozens and dozens of essays is I will say, misunderstanding on the part of students that the First Amendment protects their right to say whatever they want without repercussions whatsoever. And that's not exactly the case. Can you speak to that a little bit?
Sure. The text of the First Amendment reads in absolutist terms, right? Congress shall make no law, ... abridging the freedom of speech. And I certainly believe in protection of free speech. And one of the most surprising things in Mahanoy was Justice Breyer actually said that school officials have a duty to protect unpopular student speech, writing the schools are nurseries of democracy. But the point is that there's always been what the U.S. Supreme Court defined as narrow and limited classes of speech that are not protected. The Supreme Court held this back in 1942 in a case called Shaplinski versus New Hampshire. And even aside from what we normally think of as speech-related categories, when I try to talk to students about it, I say, well, you don't have a First Amendment right to commit perjury in court. You don't have a First Amendment right to extort money from someone. You don't have a First Amendment right to utter a true threat at someone. You don't have a First Amendment right to traffic in obscenity or child pornography. So there are these limits on freedom of expression. What I also think is important to convey, however, is if we look at the history of free expression, many of these unprotected categories started out as pretty large, and they've narrowed significantly over time. But it certainly is true, and I think the one that students need a little bit more education on sometimes is defamation. Yes, some statements can be dismissed as mere rhetorical hyperbole or just an insult, but certain statements, if you make a false statement of fact that harms somebody's reputation, particularly if you know it's false, that's defamation, right? And that's a problem. So there are limits to free speech.
Sure, and I guess a follow-up is maybe more specifically, a student's right to free speech does not mean that they would be free from social blowback, right? They may say something that is socially unpopular, and perhaps the school recognizes that they don't have the authority to censor that, but that doesn't mean that all of their peers have to be, emotionally okay with what they say.
Yeah, and I think there's a disconnect. What I like to phrase it this way: there's sort of a disconnect between the First Amendment ideal and the real. One of the most fundamental of all First Amendment free speech principles is that the First Amendment should protect offensive, disagreeable, obnoxious, and even repugnant speech. Justice William Brennan referred to that as the bedrock principle underlying the First Amendment. And I think there's semblances of that in Justice Breyer's opinion in Mahanoy. But and there have been some great I remember the very first published federal district court opinion dealing with student internet speech, I believe, was the Busink case out of Missouri, in the Eastern District of Missouri. Judge Rodney Sipple said something to the effect, disliking student speech is not an acceptable justification for limiting it under Tinker. And that's true. But oftentimes when the speech is offensive enough, it gets censored. And so there is this disconnect between the First Amendment ideal and what actually happens.
Sure. And I think, right now we're at a unique point in American history where we collectively, schools and otherwise, are having to wrestle with, what do we do with a preponderance of opinions, of speech out there, and how do we handle it if we are concerned about its negative implications on particular groups of people or on democracy as a whole. And so I feel like this is a very timely topic for us to be discussing today. Joey, I know you wanted to talk about a specific case. Do you want to?
Yeah, well, not so much a case yet, but an instance, and I don't know what exactly happens. But I just want to go back to one point: the idea that, sometimes people misunderstand when we say there can be consequences. We're talking about other people's disagreement with what you said. That doesn't mean that's free reign for government to step in and do what it wants. And also the idea that just because, as I said earlier, just because it's not absolute, as I'd even said earlier too, those areas that are exceptions are well established and pretty narrow at this point. And so people say, well, it's not absolute, so I can censor your speech now. That's not what, government, the attempt to censor is given a pretty high bar to get over to justify censorship of that speech. In other words, that speech is put up here and government's attempt to start way down there. And I see that even on a public university campus, a lot of confusion about that, even among faculty, about what the First Amendment even means for college students, and they theoretically have far more rights than even a high school student. But so getting back to the high school student, I want to make sure for both our speakers. So this was a case that came up in Olathe, Kansas, and officials said they were investigating a student who had recently posted a photo of a homecoming invitation, and this was written out on this paper or something. It was really big, and it was him asking the young woman to go to homecoming, and it said, quote, "If I was black, I would be picking cotton, but I'm white, so I'm picking you." And the school principal said any behavior like this will be immediately addressed in accordance with our student code of conduct. And this was done online. And so I wonder, where do we see the cheerleader case, the Save the Cheerleader case, applying in this situation? I mean, I know we've got a long way to go to see how lower courts start to interpret and apply that decision. But do you have any immediate reaction, either Tony and David, about what you think that student's speech is going to be protected, or does it fall outside of what the Supreme Court said in that case?
I would say it's gonna rely heavily on, as an attorney would tell you, the facts. What are the actual, what is the reach back to the school district at that point? I know this is connected to a dance that was probably school sponsored, but what effect has it actually had on the school district and its ability, as I said before, its ability to educate kids or educate students? Has there been blowback at school? Has it created issues? Is there a history of issues that might relate to this? That would all heavily affect how a court might view that specific case.
Yeah, one thing that's been a little troubling is that I think there have been 3 federal district court decisions post-Manaway, and they've all gone against the student. And so it looks like so far what federal district courts are doing is they're really parsing that language in Justice Breyer's opinion, where he says schools do retain regulatory interest over cyberbullying, harassment. He lists a long list of categories. Justice Alito, in his concurring opinion, questions whether, the dangers of drafting, harassment and bullying laws and comporting with the First Amendment. I think, obviously, I agree with Tony. The facts will matter heavily, and whether there's enough of a connection there to establish that reasonable forecast of substantial disruption. If you look at Manoy from the big picture, it does say that the vast array of student social media speech should be off limits, or maybe not vast array, but a significant chunk of it. But the more that you can tie those nexuses together between the speech and stuff that happens at school or any sort of event, and it looks like, I haven't been as pleased with the federal district court decisions that have been coming down post Manoy. It does seem to be fairly much pro school official so far, but I think we'll have to wait and see and just see when he.
To clarify for the teachers and the students, and what Tony's also alluding to is, if there are cases that, for example, if you have a history of racial violence at your school, and you are a white student and you want to wear a Confederate flag belt or shirt or something, then a school official could reasonably, or courts, I think at least I know of one case for sure off the top of my head, who've said, that would likely cause a substantial disruption at the school because there's already been a history of racial violence here, and this symbol is likely to instigate more of that. And so I guess I think maybe what Tony is saying too is the question is, what is the history of that at the school, and does this racially charged language then cause more disruption at the school in that case? I also want to make a point, though. Tell me if you think I'm wrong, guys. A point I have to make to people is racist speech is still protected by the First Amendment. So right now we're talking about in the context of a school, but once you leave that school, it is not illegal to say racist things. The better solution from our side is not to say, I'm going to censor you, but to have counter speech. Because I can guarantee you, having grown up in South Louisiana, you cannot convince racists they are wrong by censoring them. You turn them into the victim in their minds. But that counter speech doctrine becomes really important. Unfortunately, as I said in the first session, I think students K through 12 are told largely now government can control what you say. And part of that is you can't say anything that's racist. I don't know how many students we have. One of the first things they have to get out of their minds in our First Amendment lectures is, First Amendment still protects racist and hateful speech. It has to go into true threats or incitement before it's not protected.
Those can be pretty high standards to meet, as you said. Those can be pretty limited. One thing that I would kind of also point out, and I always try to point this out when I'm doing training for administrators or board members, is sometimes you get a weird result where certain speech at one school district is not an issue. It's not something that the administration would have any kind of authority to discipline for or restrict. While at another school district, you could have the exact same speech. Maybe it's a different student body with a different cultural makeup, and that speech is now something that could be restricted. And again, that really just emphasizes the fact that it's not about the content. And as administrators and board members, they have to remember that they are a political subdivision of the state, so they are the government. And so anytime they take action to restrict any kind of speech or discipline for speech, whether that be like in Mahanoy, taking them off of an extracurricular, which many tend to think, oh, it's an extracurricular, they don't have the same rights. Any kind of consequence that comes about because of speech is likely going to get you into a First Amendment issue, and you have to go through this analysis of, is it appropriate? Does it meet the standards in Tinker? Does it meet the standards of one of the other cases, Frazier, for example, before you make that decision?
Your comment about extracurriculars is where my mind was. And so if I put myself in the shoes of a student or a parent or teacher, where's that line drawn? So I think most people would kind of understand things that happen at school are maybe more clearly defined, and then you've got extracurricular, you've got sports, you've got dances. But like, what if it's a fundraiser for the PTA, or it's a fundraiser for a sports team, or something that's like 2 degrees removed from the traditional school day? How do you define the line, if it exists, of where the school's authority extends?
Yeah, that's a good question. I've seen some cases even where a student, and this is kind of outside of First Amendment, but was doing some activity over the summer, and the school is trying to discipline for their activity, not necessarily their speech. So there definitely is a limit to what a school district can do. It's not necessarily clear to me, at least in terms of some of these outside, extracurriculars. If it's something that's sponsored by the school with students that are either required to be there or asked to be there, I'm thinking particularly of the Bong Hits for Jesus case out of Alaska, where the students were told to come out and they can watch the Olympic torch go through town. It was an activity outside of school, but students were asked to come as part of the school day, and that was still really a school-sponsored event. So again, that's one of those areas that's not necessarily clear. There's always the fun part of being an attorney, of those uncertainties, where you get the questions about, well, what if this and what if that? And it's hard to say necessarily there's a bright line of what would be considered a school activity. But generally, if it's something sponsored by the school and the students are told to be there, or as part of some kind of part of the curriculum, then that would definitely fall within what we would consider to be the school day. Outside of that, then you're looking at those factors in Mahanoy of, to what extent is it affecting the school?
Sure. Yeah, I appreciate the gradient there, and the uncertainty, because the next place my mind went was about the end of the school year, what happens during the summer, and if the summer doesn't count, then what about spring break or fall break? Like really trying to get down, and I'm sure that's why we pay attorneys the big bucks to hash this out for us. David, I wanted to go back to what you said in your opening statement about cautioning, just telling people to be conscientious of what they post on social media. Could you just tell us a little bit more about that, and kind of how you frame that guidance for students in particular?
Well, certainly. I mean, somebody said it better than I did. Like, free speech has consequences, and there's a certain type of speech, if it's considered to be targeted harassment or bullying, that may run afoul of violating a school code of conduct that prohibits cyberbullying. In some jurisdictions, there are actually criminal cyberbullying statutes. Now, some of those have been struck down. I know one of the People versus Marquand M in New York, and I can't remember the name, the Bishop case, I think, out of North Carolina. There have been some laws that have been invalidated. But I think a big concern is there's a difference between really intemperate offensive speech and what school officials and others might view as targeted harassment or bullying, where you're really singling out a specific individual or a group of individuals, small group of individuals, and targeting them. And I think those type of posts you really have to be careful about. Second area I would warn students about is there is an exception for true threats, and the U.S. Supreme Court created that back in 1969, a case called Watts versus United States. It involved a 19-year-old African-American protester who was essentially protesting the Vietnam and the racially disproportionate application of the draft. And the court said that we have to distinguish between what's a true threat and what's protected speech. And frankly, the Supreme Court has struggled mightily in the ensuing decades on actually defining what is a true threat. But the danger for students is that the lower courts have expanded the true threat doctrine in the school context, particularly post-Columbine and some of these other school shootings, to where sometimes violent themed student speech even if it's not a true threat, is considered to be a true threat. And there's all sorts of punishments imposed upon students. And the courts use a test from the Eighth Circuit called the Dinwiddie Test. That's a very flexible test that allows school officials to look, for example, at the history of the student, their disciplinary record, the reaction of the recipient. And it's a very flexible test. It's, I often talk to my students about whenever you see a totality of the circumstances type analysis, that tends to favor the government, not the individual. But I do worry about those students who are really creative, but they engage in violent themed expression, and then suddenly they're deemed to have uttered a threat. There are all sorts of cases like this. One of my favorite from years ago is Bowman versus a Blue Stem Unified School District out of Kansas, I believe, where a young student did a piece of concentric art and she posted it on the door. It's like, who killed my dog? Who killed my dog? Did you kill my dog? I'll kill you. And it really was a piece of art. And instead, the court found that it was a form of protected speech. But that still didn't stop the school from imposing discipline on her and then wanting her to go see a psychiatrist and evaluate her. And there's a lot of cases like this. There's a lot of examples of it where it's violent themed. Schools have a duty to protect students from violence. Student posts or says something that's considered off, and there's all sorts of problems. There's a case that came out this week from the state of Wisconsin where a kid posts some stuff on Instagram and Snapchat, and another student or another young person thinks that it's a true threat, and they both happen to be at the same movie theater. So the one kid goes and tells the authorities, and the other kid ends up getting arrested. And the court here in this instance says, well, this was one of these weird coincidences and it was an overreaction. But it just shows that if you sometimes engage in violent themed expression, there can be these really negative consequences, and they're not even intended. It's a lot of times it's somebody that, like the N. Ray George T case out of California, where the kid just was into dark poetry. So that's concerning. I think the other area that's worth mentioning is there's all sorts of public employees who've been disciplined for social media posts. This is more teachers and students, so maybe drifting off track, but we've seen a litany of cases where teachers get online and post stuff that's either negative about their students, negative about coworkers, or negative about the principals or the school board. And while the Marvin Pickering case back in 1968 protected teacher Marvin Pickering's letter to the editor of the Lockport East Herald because he was talking about people that he didn't work with, didn't have close working relationships with, what we're seeing is that speech, that negative speech by teachers about people in their specific school, has led to a significant number of teachers being disciplined and or fired. So that's a real problem too.
We have a case in this state that dealt, I was trying to look it up just now, it was a long time ago, where a student wrote, she was talking about, I think, her English teacher, and she wrote some not so nice things. And then she wrote, I think she wrote it 137 times, if I remember them, killed the B word over and over and over and over and over again. And then she apparently dropped that in the hallway. And the school, I think another student picked it up, but gave it to the school. And the school waited 3 days before they even brought her in. And the federal trial judge, I think this was in Owasso school district, actually sided with the student, but in part because of that reaction that they waited 3 days. They couldn't, the court said you didn't see it as a real true threat if you waited 3 days, if you really thought she was going to do something. On the other hand, the court did say they have an obligation to investigate this kind of speech, but they can't have simply a blanket prohibition on speech that might have some violent connotation to it, but they should investigate. And as I think we've all said at one point or another, it comes down to the facts of the case. And And in this situation, waiting 3 days clearly showed they didn't think she was actually a true threat. So I mean, if you thought she was going to kill somebody or a teacher, you would act much sooner than that, like as in when you first got, the note was handed to you. So.
You know, another one, if I may tell a story, this is one I use as a horror story too, is the Adam Porter case out of Louisiana, where this kid's younger brother, or no, Adam Porter himself draws a picture of his school being firebombed. And he writes it in this sketch pad, and he puts it in a closet where it remains for 2 years. And then his younger brother takes the sketch pad, not knowing the drawing is in there, takes it on the school bus and shows his drawing to another student. The other student flips through the sketch pad and sees the fire bomb drawing. Adam Porter is arrested and spends 6 days in jail for pure speech. For pure speech that was uttered 2 years prior. It was drawn 2 years prior. I found that it's called Porter versus Ascension School District. I still remember it. And that was just stunning to me that happened to the poor kid. What made it worse is when they go search the kid, they find a box cutter on him. Well, this is shortly a couple of years after 9/11, box cutters. Well, he had a part-time job at Kroger's. But now he's this wild, dangerous threat, and gets locked up for 6 days. Wow. Terrible.
And there's also, from the school side of things, there is pressure on the school districts in terms of, there's state legislation about when a school thinks that there might be a threat, that it has to be reported. Obviously, other liability concerns and everything. Columbine and post-Columbine has really put administrators on edge that anytime they see a threat or something that they think could possibly be a threat, their immediate reaction is, we have to do something, we have to do it quickly. And we always try to explain to them, First Amendment can protect speech even if you don't agree with the way it's written or the content. And unless you can really show that this is a threat against your school district, against your students, there's limitations there. And I just feel there's that pressure on school districts to act, which is obviously making things more difficult for students as well. I don't always find it the case that schools are out there searching. I think this is the case with some nationwide. I've seen some litigation over this, but schools aren't necessarily out there searching, just waiting to find something that they could discipline a student for. That's not necessarily the hope of the schools, just to try to bring a student down. But there is a genuine concern of how do we react to some of these threats that we perceive to be a threat. In fact, there is a case in the 10th Circuit right now, I believe, where a student in Colorado had dressed up in a Nazi uniform and made a comment about going after those of the Jewish faith. He thought it was funny. It was taken to be a threat by the school district, and the student immediately took down the post within 30-45 minutes, apologized for it, said he didn't really mean for it to come across that way, and we're waiting to see what happens with the 10th Circuit on that one. So it's one of those where it's a close call, where the school district's trying to respond to a situation, but they have to be careful in how they do it.
That's interesting. I mean, it strikes me that there are perhaps competing and moving incentives that might differ for school boards or for school administration, and then for students as well. Something that David said earlier made me think about this. I guess I'm just going to ask outright on behalf of students everywhere, are public school codes of conduct, including dress codes, are they compatible with the First Amendment? Where does that line get crossed?
Well, I can give you one example of one I found very interesting. There is a degree of, certainly a significant degree of deference that's given to schools, and you'll see a strain of thought, and particularly the federal judiciary, well, they'll say something like, we're not the superintendent, and we have to defer to school administrators who are making these difficult judgments. Let me give you an example of a provision of a dress code that was invalidated. And it was a dress code in Virginia, a school district in Virginia, that had a provision in its dress code that prohibited any clothing that related to weaponry. And the idea is that we don't want to promote guns, we don't want school shootings, we don't want violence. There was a kid who wore a T-shirt. He went to a shooting camp with his father and was very proud of it. And so he wore the shirt to school and was prohibited from doing so. The NRA funded his lawsuit, and it went up to the Fourth Circuit. And the Fourth Circuit ruled that that provision of the dress code was unconstitutionally overbroad. And they did, when you find out whether something's overbroad or not, there has to be substantially overbroad. That's a limitation that the U.S. Supreme Court developed in a 1973 case called Broderick versus Oklahoma, I believe. But what was very interesting is they said, well, if we look at the state seal of Virginia, it has a woman standing over holding a spear, and a spear is a weapon. And then it provided other examples of a lot of school mascots, shirts with school mascots, and they have weapons. And so the Fourth Circuit, not always known as a bastion of free speech, invalidated that part of the dress code. So there are challenges that are made to specific provisions. For example, if you have a dress code that says no inappropriate clothing, and you don't define that, then I think you're opening yourself up to both an overbreadth and a vagueness challenge. That said, the bulk of case law will uphold dress code policies in toto, but give students the right to protest those dress codes. We had a case in Tennessee, at a Wilson County, Tennessee, where there were students who objected to the dress code, mandatory dress code, and I think they wore black armbands mirroring the Tinker plaintiffs. And the federal district court said, no, the dress code's constitutional, but the students do have the right to protest the dress code respectfully. And there's a lot of cases we can look at with regard to dress codes. I think the Fifth Circuit has a few of the leading opinions, and then there's the Jacobs opinion out of the Ninth Circuit. Canada versus Bossier Parish School District out of the Fifth Circuit is a good one. But what they'll say is that the dress code as a whole might be passed. It's not intended to suppress free expression under the O'Brien test of the First Amendment. It's designed to create an environment that's more conducive to learning. That said, yes, codes of conduct, specific provisions of codes of conduct and dress codes can be challenged, but there often is a significant level of deference given in this area.
There was also, I don't think it was the same case. I think this was middle schoolers they had to wear a uniform, and to protest the uniform, they had little buttons that showed Nazi youth marching, and then they had the circle and the dash through it. And teachers said, well, this is pro-Nazism, and the court sided with the students and said it was a public school. They were protesting a government policy. They're still wearing the uniform, but they're showing their protest of it, and it's a government policy, and we're entitled to do that. But sometimes talk to students too about, it's not just always go to court and challenge it in law. Sometimes it's a matter of common sense and going to your school board. For years, both at this and some other conferences I do with high school students, I was told that students could not wear any athletic apparel except for OSU and OU, University of Oklahoma and Oklahoma State University. And I asked, well, what's the justification? They said, well, it was for gangs, because there's gang violence here, and that will be the problem. And I said, well, the first thing is that tells me that no self-respecting gang would ever wear anything from OSU and OU, which shows the stupidity of that policy. Are you telling me they can't wear American University T-shirts? That's college apparel. So I would tell students for years to argue about this. And I think it was Oklahoma City School District where finally a student wore, it was either Michigan or Michigan State. His family had just moved from Michigan. His parents got upset when the kid was told to take that off. And they finally went to the school board and said, this is kind of nonsense. For one thing, there's not gang violence in every one of these schools, and it has nothing to do with college apparel. And when the publicity came out, I think the school district changed that. And by the way, the student and his parents were also invited up to the university they were representing and were celebrities at halftime, which is a good idea. But it's, I see at some schools when they come to the conference in person where students have pink hair and, are dressed basically however they want. And then at other schools, and I know my son went to Edmond North High School, and we as parents were brought in before their freshman year and told the student dress code was they can't have holes in their blue jeans or they'll be sent home kind of stuff, much less they can't have colored hair. And sometimes, okay, so what does that have to do with learning? And clearly the culture in other schools is we're worried about you showing up and we want you to learn, and we don't care what color your hair is. It's not causing a substantial disruption here. So sometimes that's a matter of going to the school board first and trying to get some common sense applied on these kinds of policies instead of automatically we need to sue. And even getting sometimes, I don't think the school districts or the school boards often realize what the policies are and how they might be applied in some of those cases.
Yeah, one other thing I wanted to throw in about dress code while we're talking about that topic. I'm really proud of Oklahoma because we had a case going back to 1976 where our Supreme Court found that length of hair was just one of those things that the school couldn't control. It wasn't reasonably connected to its educational mission. And in the 1970s and 60s, that was a question among many of the circuit courts of lots of these hair cases of where does the school's ability to regulate something like that start and stop? And the court there didn't even rule based on First Amendment. They ruled based on what is the authority of the school board. So there's lots of different things when it comes to dress code. There's the First Amendment. There is what is the school's authority, but also, is it being applied differently based on gender? Or, are yoga pants prohibited on females, but it doesn't say anything about males or short skirts? That's one thing we've seen a lot and have dealt a lot with. So when it comes to dress code, there's many interactions with the law, and many times when it comes to First Amendment issues that we're dealing with, it has to do with a student that wears a shirt with a specific message on it, and is this going to create an issue?
In that case, and actually I have my students read some on that case as well, the state Supreme Court here. And the court was saying, because if you're regulating it for school, you're regulating it for 24/7, actually, and found that it had no connection to teaching and learning to regulate the length of hair. And yeah, and I find people that are surprised that case exists in Oklahoma. It can, and I find sometimes running the school officials, teachers and stuff, have no idea they couldn't actually control that. So
a lot of them are concerned about, football players with long hair, and is it going to create a safety issue? And I always try to point out, well, there's lots of professional players that have long hair too. So,
that's correct.
And to show you how difficult these are, piggybacking right off my colleagues here, there's a federal district court case in Nashville, Tennessee, where a kid was playing football at Hendersonville High School, and he had long hair, and the coach said, "You don't play if you don't cut it." Sues in federal district court, and the school wins. So it's not always, it's difficult. I think a lot of times those are brought under a due process liberty interest. And then the other thing to keep in mind, too, is sometimes the adoptions of these dress codes and uniforms really bother parents. And so parents will file a 14th Amendment-based challenge. They try to sort of piggyback that to Meyer v. Nebraska and some of these older cases in the 20s about that this infringes on the parents' right to rear their children as they see fit. And that was an element of an amicus brief that I actually joined in the Mahanoy case that was principally authored by Catherine Ross. But, when you start disciplining students for purely off-campus online stuff, really that should be a matter of parental discipline more so than school discipline. And that was, I think that was a significant part of what Justice Gorsuch was, or Alito, one of them was saying in their opinion and their concurring opinion.
Yeah. This discussion of dress codes reminds me of when I was in 8th grade, and the school that I attended in Minnesota allegedly had some gang activity, and they came over the loudspeaker one day as I sat in choir and announced that we would no longer be allowed to wear solid blue and black together because that was gang colors. And I was sitting in choir with brand new black jeans and a blue silk shirt that I was very excited about, and came home, almost in tears to my mom, like, I finally got the shirt I wanted and now I can't wear it. And so to my knowledge, no one was ever actually sent home for their clothing at the school. But I wish I knew this stuff back then. I might have pushed a little harder.
Yeah, we have a state law that allows school boards to prohibit gang-related apparel, which a lot of schools will prohibit the color red or the color blue. There is one good case out there. It's older now. I think it's from 1993, called Jeglin versus San Jacinto Unified School District, where a high school was prohibiting the wearing of all sports-related apparel. And the federal district court there did invalidate that on First Amendment grounds. So there is some good case law out there, but you really have to hunt for it sometimes if you're on the student side in the dress code arena.
Yeah.
One thing I always try to point out for schools too is usually I try to tell them you need to try to be able to establish that there is some hint of gang activity in your school district. If you are a very rural school district with a very small student population, it's much harder to make an argument of banning what you would call gang-related apparel when you have absolutely no history of it being not only within your school, but within your city or even county. So I think that can be a factor.
Great point. There's a case, I don't know why I remember this case, the Chalifo case out of Texas, Chalifous, I think. The kid was an honor roll student, straight A's, and he wears rosary beads that I think his grandmother had given him. And it's gang-related apparel. Now, he ended up prevailing ultimately, but it took the intervention and lawyers to help him. And that's exactly right. Like some of these definitions of gang-related apparel are just too all-encompassing,
Yeah. Well, we've got just a few minutes left, so maybe we could go around. And a final question is, what do you see as the next frontier, or where do you see the struggles on balance about First Amendment in schools and with school boards that we should be paying attention to in the next few years? And Tony, I'll start with you.
I think right now there's still just a lot of uncertainty when it comes to online postings. I mean, that's where most of speech is happening nowadays when it comes to students and even adults. And school districts are really going to have to grapple when it comes to threats and things, bullying online, of where that line is. Because yes, we do have a clear answer from the Supreme Court. There's still lots of questions to be answered in terms of where does that line start and stop.
David, how about you?
Yeah, I definitely what Tony said. The Tinker case itself, there are really two parts to that case, and one is dominated for decades: reasonable forecast of substantial disruption, or the substantial disruption test. The court also indicated that one of the reasons why John and Mary Beth Tinker could wear the black peace armbands is they didn't interfere with the rights of others. And so this other so is often referred to as the forgotten part of Tinker, invasion of the rights of others. And the United States Supreme Court has never told us exactly when student speech invades the rights of other students. We just have a small smattering of lower court decisions. And in the age of cyberbullying, that's something that's going to have to be decided, is when exactly does student speech invade the rights of others? Do we set that on a sort of a tort liability type standard, or is it looser?
And I would agree with Tony that the I think David actually said this earlier too, we're a long way from actually figuring out how the online speech is going to be dealt with. But another version, and of course, online social media keeps changing and evolving to different formats. But I think one thing we may have seen more, and as we see more online learning, the cases or situations where students are being punished for speech at their own home while they're online, and it's not even necessarily speech they're saying or doing, it's something in the background. So as that online presence comes into our own homes during the day for the education, that may be an issue. Pandemic sort of brought it to the front, but it may continue, I think.
Yeah. Well, gentlemen, thank you all for being here so much. This has been a wonderful discussion, and I know I have learned something. I hope that our audience has as well. But have a good week. We'll talk to you later.
Thank you.
Thanks so much.
Thank you all.